officer did not accept their version. Accordingly, orders were issued confiscating both the vehicles. As against this, Exhibit P1 order, the petitioner submitted Exhibit P2 appeal before the District Collector Todapura. The case of the petitioner was that if at all any sandalwood was found in the jeep, it was without permission from the petitioner. The petitioner was not driving the vehicle. It was also his case that the forest officials had previous enmity with the petitioner and that there was no evidence that the jeep was used for committing any forest offense. It was also his case that no mahazar was prepared by the officials at the time of seizure, apart from the allegation that no inquiries were conducted by the divisional forest officer consistent with the principles of natural justice. The learned district judge passed the Exhibit P3 order upholding the confiscation order in Exhibit P1. After referring to the entire files, it was found that there was mahazar prepared by the forest officials according to which the jeep was involved in the forest offense. The learned district judge repelled the contention of the petitioner that the vehicle was purchased only 3 days prior to the seizure of the vehicle, observing that cannot be a reason for absolving the petitioner. It was found that though the version of the petitioner was that the driver was engaged through the General Secretary of High Range Automobile Workers Union and strict instructions were given not to use the vehicle to carry any contraband articles, he did not care to examine the General Secretary of the Union or any witness to prove the same. Therefore, the contention of the petitioner seeking the benefit of subsection 2 of section 61D of the Kerala Forest Act was not found acceptable. The court found that the commission of offence was in the wee hours of 15/7/2001 and in case the petitioner was cautious enough, there was no possibility for using the vehicle at those hours. Regarding the contention of the petitioner that the principles of natural justice was violated while issuing Exhibit P1 proceedings, the learned judge, after perusing the files, found that the authorized officer has complied with the mandate of Section 61D of the Kerala Forest Act. In view of those findings, Exhibit P1 order was upheld. It is the order Exhibit P3 upholding Exhibit P1 order which is under challenge in this writ petition para. The learned counsel for the petitioner raised several contentions with the support of catena of decisions. In the meanwhile, immediately before the hearing, writ petition was also got amended, producing the orders passed in the cases which were registered by the forest officials and producing the judgment in CC numbers 219 and 126 of 2003, and it was argued that the forest officials could not prove the charges framed against the petitioner.